Only state government has not filed any.
Yeah.
Possible customer selection model. Project ID number 168, we want to done with this.
About already called events for yeah, over and many losses were advised that it was an ad-hoc bench. That is why on that day the matter was put before today. In the meanwhile, there are many IDs may come. But the only issue involved is that once the notification was filed, the Honorable Supreme Court has already passed the order that any steps taken thereto are also declared invalidated. Here the selection and appointments were made subject to the outcome of the Supreme Court. It has already come. Now, madam, these BEd candidates should be declared ineligible. They are occupying the vacancies for which we should have been selected. So that is why, madam, my arguments were already over. There's sitting on the bench. I can just surprise with the facts within 10 minutes. Now, in between the day when the lottery kept this matter today, what has happened is that from the High Court of Bihar, based upon two judgments of the Supreme Court, there was a view taken up that the Supreme Court judgments passed in the matter of Devesh Sharma and the Bihar judgment, they are binding in nature upon the High Courts. In that reference, even two SLKs were filed by the state of Bihar as well as the BEd candidates. Both these SLPs were withdrawn after the view was taken by the court that no interference would be made out. So, Maharashtra kindly consider that as of now, once the Supreme Court has quashed the notification, the BEd candidates who were appointed in pursuance to that notification, they cannot remain in service, more particularly when their appointment was subject to the outcome of the judgment.
Just apply your lost in regard to latest development. SLP has been filed with the Supreme Court on behalf of some of the candidates from the state of Uttar Pradesh. And they have sought a direction to all the states of the India to quash all the appointments which have been made pursuant to the new notification of the NCT, which has been quashed by the Supreme Court. Now, all of the matter was listed yesterday before the Supreme Court. That matter, my lords, just kindly have a look. This is the order passed by the Supreme Court. This order was passed on 31 days. It was not yesterday, 31. 31/10, that matter has been adjourned for 4 weeks. But my friend is talking about the Bihar. The reference of the Bihar matter was also made before the Supreme Court. That earlier Supreme Court has observed something regarding Bihar. Now, let's have a look for the case, and I will just read the ruling which has been claimed in the said petition. This is a writ petition filed by one Guddu Bharat.
So that Bihar matter was withdrawn.
Bihar matter was withdrawn. In this matter, the reference of Bihar was also made.
It who's in this Guddu Singh
This
matter.
Guddu Singh matter, Guddu Singh's really filed this. I'll just read Guddu Singh's relief.
This is adjourned for 4 weeks.
Yeah, the judgment for please have a look what is the relief he has claimed. I'll just read one of I'm getting the copy or a hard copy of that. The relief one of which he has claimed is that in the aforesaid facts and circumstances of the case, it is therefore most respectfully prayed that this honorable court may kindly to please to issue a writ order or direction in the nature of memorandum inter alia directing respondent number 1 and respondent number 2 to pass necessary order for cancellation of the appointment made by various states in classes 1 to 5 on the basis of the notification dated 28/6/2018 wherein number so and so published by the respondent number 2 NCT, which notification has been passed by this honorable court in appeal number 5068 of 2023 and other connected matters, Devesh Sharma and other versus state of Rajasthan. So this relief that these appointments made pursuant to the notification of the NCT may be passed. That direction is sought in that matter. Yesterday the matter was approved. The reference of the Bihar matter, I also have the video on the YouTube. I have downloaded that. I have that video also. Where the matter of the reference of the Bihar Supreme Court said in that case you should go and review in the Devesh Sharma's case. As far as this case is concerned, where this matter is now under consideration, that has been adjourned for 4 weeks.
This is for, what?
One of the candidate is from UP, but he has sought cancellation or appointment at all by
So
state.
what he's seeking execution of Devesh.
Yeah, what he is saying is,
Just a minute.
so what he is saying that since Devesh Sharma's case, NCT notification has been passed, and now it has been held that the candidates having BA degree are not eligible for appointment as a primary tutor. Therefore, in the interim period, after notification of the MCT and till the date of Devesh Sharma's case, whichever appointment have been made in the entire India, those appointments may be questioned. This is the prayer made in that question.
In effect, it is, they are seeking
Execution, yes, correct.
execution of Devesh.
Correct.
So
So now the issue here which they have raised is also similar. They say in the, on the basis of the law declared by the,
how does this subsequent development affect the hearing of this case?
because they are also seeking the same relief. They are saying that because of Devesh Sharma's case, the NCT's notification has gone, and therefore the appointment which have been made in the state of Madhya Pradesh, they may also be. This is their relief. That is the basic relief. So, the matter, Malad, since the Supreme Court is seat of the matter, would be appropriate if this Malad is adjourned for 4 weeks.
Now the Supreme Court will.
Or-
Article 35 in a state of this matter.
Secondly,
How will
Malad,
it impact state of MP?
no. But when it comes in the, when it comes in,
Notification was challenged in the state of MP. You took the plea that a matter in Devesh Sharma submitted before the Honorable Supreme Court. There this Honorable Supreme Court that will wait for the Supreme Court judgment. Supreme Court says that you are ineligible. We have put an application that now you cannot continue with your eligibility.
situation.
Your notification is already gone.
Same situation.
You
as-
are saying that it's your
Secondly, Malad, as Mr. Gupta said, this is a matter which cannot be decided without a reply from the state government. It's a case, Malad, we are, the reply from the state government has to be taken. The state is yet to find reply. It's not that simple as my friend is saying that Supreme Court has passed the order in the case of Devesh Sharma. Malad, there are 70-80 cases. It would be the effect. The Supreme Court in the judgment of Devesh Sharma itself has said that the state should not have ignored the NCT notification as long as it was in existence. Therefore, Malad, the repercussion of that is
Copy from the High Court of Bihar.
my submission is this one that this matter.
They have provided a copy of the comparison of High Court of Bihar. That after
Bihar, Malad, yesterday we had been
instead of rupees and fees that.
Bihar yesterday it was mentioned before the court. That Bihar case court has said like this. They said no, you go in a review before Devesh Sharma. If you feel right. As far as this matter is concerned, so my submission is
Devesh Sharma is not reviewed. It's a law of land.
so Malad said to Malad, it will be a big
It's not look from the state of Bihar. It provided the copy. Purposes of it provided this compilation.
and the Bihar state Malad makes we see that the court had again left it to the state of Bihar as far as that order is concerned.
What it meant.
Yes, why was this Gurdu Singh filed?
Gurdu Singh is fine, Malad, that they are now because they say that after the declaration of law by the Supreme Court, the state government.
This must be filed by the diploma.
Yes, diploma. Yes. He said that all these appointments should be. So now that
Why a fresh petition?
It was not even required.
because the reason being, Malad, Supreme Court has only declared the law. Supreme Court has not said as to what will happen to the cases or the appointment which have already been made. That is the issue before that, Malad, this issue has to be examined. Because the Supreme Court in paragraph 34 of Malad Devesh Sharma itself has said that the state of Rajasthan could not have ignored the NCTE notification. Malad, what had happened, the state of Rajasthan did not invite. The state of Rajasthan also did not invite the application, did not accept the application of the candidates who were having B.Ed. Supreme Court said that was illegal. Once the NCT notification was in existence, as long as it was not declared illegal, the state of Rajasthan was bound to not follow that NCT notification. And that is the issue exactly here also.
NCT notification was declared illegal by the High Court of Rajasthan on 25 11.
That was
How does this, the pendency of this case before Supreme Court, how does this hold us back from proceeding?
In the state of UP, well, this is the matter for the state of
And here the petition is by
Here is, it is.
peer candidates.
But here, my lord, the petition is filed by the candidates who are DLED, who are having DLED qualification.
Yeah,
Yes. Similarly, my lord, that is the candidate, Guddu is the candidate who is having DLED. Guddu says that before the law was declared by the Supreme Court, the state of UP has made about, my lord, 60,000 appointments of the teachers, in which the candidates having B.Ed degree have also been appointed.
So more or less it's asking for sympathy
No, it's not.
to save our services, save the services of peer.
My lord, it's
Appointing.
one of the candidates. It's not.
Basically that.
But it's not simple. It's a law. Law, my lord, because any law, my lord, it will be.
No, probably you all were showing us some order are subsequent to Devesh
Yes,
Sharma.
one Krishna.
Correct.
So that indicates that they wanted these people out, the beard.
My lord, Supreme Court has stated yesterday. Supreme Court had said yesterday in that hearing matter. I have got.
Now, the best course would be that they have to be out, they have to come out of service, and then thing has to be worked out. If some beard degree holder also holds a diploma, then of course he is entitled to be adjusted, but not otherwise.
Others will have to see the provisions of the RCA. Others will also have to see the earlier.
No, that the Supreme Court has seen already.
No.
Why should we go into all that?
Supreme Court has, please, what Supreme Court has said that NCT should not have issued this notification declaring the B.Ed candidates as eligible to apply for the. This is what the Supreme Court says, and therefore the NCT regulation has been declared to be, NCT notification has been declared to be illegal. Now the question before the Supreme Court is, or this issue of appointments already made was not an issue before the Supreme Court. Supreme Court has left it to the states. Even in the order of Bihar also, they have said we leave it to the state of Bihar. Now the issue, what my lords have to examine.
Leave what to the state of the.
One of the issue regarding the appointment which have already been made. Because the question, my lords, please see paragraph. If my friend has just.
The fate of those appointments.
My lords, please have a look on paragraph 34 of Devesh Sharma. Paragraph 34, Supreme Court says that the NCT notification held the candidates having their degree as eligible. In the state of Rajasthan, despite that notification being in existence on the date of advertisement, the candidates having B.Ed degree were not held eligible. They were held ineligible, despite the NCT notification in place. Supreme Court said in paragraph 34 that the Rajasthan High Court has rightly held that until the notification issued by the NCT was declared illegal, it was not within the domain of the state of Rajasthan not to apply, not to permit the candidate of B.Ed in participating in the process of selection. Because on that date, the notification was very much in existence. Supreme Court said that once the notification was in place, one of the candidates having B.Ed degree also has been permitted to participate in the exam.
Give it an expression before the permanent bench in the roster. The other list. So then, of course, the adjustments will take place between benches. If you want, then we'll hear it, pass it over.
In my mind. For one, it's not that it's such a, which is going to have very wide ramifications, consequences of my law. Now the down of the state government is very important. Precisely that is the reason why matter was exchanged.
It was her. Senior counsel, sir, I am also there, Lordship were also there, it was her. They were replying, then court master replies that it was an ad hoc bench. Then the matter was split over.
But
what my contention is that 25,000 vacancies, but 22,000 have been picked up, 2,000 vacancies are vacant. Why? Because we have not found, the government has not found eligible candidates. Meaning thereby that we have not stressed on the rights lot of the DLED candidates. Still, thousands of vacancies are vacant. So this is an academic exercise in which my learned friends, petitioners, counsel, clients are indulging.
They are already appointed also.
They are, most of them are already appointed, even if not appointed. Not this honorable court will be seized of the matter if some right is transferred.
See,
It is not a PI.
Petitioners here are diploma holders.
Yes, they are already
They are,
appointed.
all the petitioners, Lord, they are diploma DLED holders.
They are already appointed.
Statement.
They are already
Except in one petition, in other petitions, none of the petitioners have been appointed. This is there.
Chalo,
If they can show up, this is why we are.
There should be no dispute on this kind of a fact.
yes.
It should be very, very clear. Madam. You should come and state
My learned friend, in one of the petitions, all of them have been appointed.
in one of the petitions.
Chalo, we get two or only some of them.
All right.
And many petitions. Now, my contention is,
All
my
right.
contention
Yes.
is, if anyone's right is transgressed, or anyone has been brought down because BA candidates were more competent, all this, that. My contention in my return is that out of 25,000, only 22,000 appointments have been made. 2,000 appointments are vacant because these DLED candidates could not qualify. So their right is not violated. Our participation, my lord, in the election process has not in any way prejudiced or brought the competition. This is wrong. There is no competition is still there because they have not even qualified. And
Mr. Rupra, we have, please decide.
only one more thing, Lord, just we are not shying away from arguments, but we don't want, Lord, that contradictory orders should be passed into litigation. My learned friend has given us the.
No, would you like, please argue the matter so that we can finish it.
What the submission is, or we are ready to all. There's no difficulty on it now. This submission is, or will it not be appropriate to have a reply from the state government? It's the state government which has to give out as to how many posts were advertised, how many appointments.
They have not filed any reply.
They won't find. How many posts are still vacant? Whether they are prejudiced because of our continuance in service. Yes.
What is the state doing since the last 1 year?
They will not allow because it was their rule. They have given appointments. They want them to continue because that would create a problem for them if someone is intentionally and deliberately they are sitting over it. They will not find this plan.
How can you say that they will not? The court says.
Mr. Bajpayee, in 1 year, state has not come out with any response. Why so? So this is under which department? School education, public instruction. Then what?
They have to say they let the state government also file response.
You will have to, in fact, disclose a lot many things that whether there is any B.Ed appointee who also holds a diploma, whether there is B.Ed appointees who do not hold a diploma, chart has to be made. Then can their appointment be axed because of their judgment or not? Whether they can be adjusted or not?
They are not in view of the RTE Act, whether the B.Ed
So
candidate.
that has been decided. That question has been decided by the Supreme Court.
No, the Supreme Court has said.
That the notification is bad in law.
No, the Supreme Court has said candidates having B.Ed, but there is a provision in the RTE Act that candidates who are having B.Ed, they can be made qualified by undergoing that process. That is not a step down. It's not a step down.
Actually, see the courses are totally different. The diploma course and the graduation course in education, and they are different. Different subjects are being taught, different type of education.
We can't comment on that.
Teaching is like,
No, it's not. Please.
This is only for primary
Another
education.
section, 20
Primary school.
primary teachers. Our section 22 of the RT.
Hmm.
When the RT Act came into existence,
Hmm.
at that time also the BEd candidates were not eligible.
No, we are ready to hear. Please argue the matter.
If they are Manoj, these are not Manoj.
But states reply is a little.
But the states are
No, Mr. Council, don't you think states reply is
This
necessary?
will not be required
Why
for
not?
the reason one.
Why not?
Now let me answer this.
Yes, let him.
What the reason one? At the NCT notification being binding on the state of Madhya Pradesh, they came up with their book only to bring it in consonance with the NCT note. Now the NCT notification was quashed by the Rajasthan High Court with 30 parallel April. Two, the Honorable Supreme Court by upholding the judgment of the Rajasthan High Court also declared it viable.
What did the Rajasthan High Court say about
Said the
the?
NCT notification is
No, that is understood.
Ma'am.
What did they say about the appointees?
Instead of Rajasthan Malok, the Honorable High Court granted stay on the appointments. At the initial stage itself, that they will not be given appointment because the High Court was aware of the fact that under the primary education, only DLED persons are having that ability to teach, that training can let them to go and take over studies of a child.
So there, this problem was not there.
It was not there.
They correct that the Rajasthan High
I was the concept Rajasthan High Court, I one investor aware, I am telling that.
Where is that judgment of the?
That is placed in the compilation.
It is wrong that Rajasthan High Court had granted this state. In the state of Rajasthan, the candidates having here were not permitted to participate.
See,
They were not permitted by the state itself.
Okay, so
because I also want to let me address.
just that means, Mr. Gill, that no person with B.Ed degree was appointed there in Rajasthan.
Absolutely.
So did not have, High Court did not have to deal with this kind of a
No,
situation.
what has happened?
Absolutely.
What has happened is there were two petitions filed. One was with the B.Ed
And
candidates.
what about the other states?
In other states that went from Bihar, where the appointments were made, there in Balakrishna
Of B.Ed.
B.Ed candidates, there the Honorable Supreme Court says that all steps taken subsequent to this notification stands invalidated. That matters what has happened is, in High Court of Bihar, the matter was filed that look, there is a judgment of the Supreme Court. There was also an interim order in the Chhattisgarh matter, which judgment would be binding. The High Court of Bihar said that the Supreme Court judgment is binding, these candidates cannot continue in service. It was specifically clarified. Against that, instead of Bihar as well as Bihar candidates were in SLP. And there, my lord, the one SLP was listed before Justice Bopanna's bench. There they said that it should go before the bench of Justice Anuruddha Bose, who delivered that Devesh Sharma's judgment. The matter went before the bench of Justice Anuruddha Bose. Thereafter, arguing it for half an hour, ultimately the petitions were withdrawn. I have placed both the matters on record. That the High Court of Bihar has taken up this view. That the Devesh Sharma as well as the Balakrishna judgment, they are binding. Bhagwan Krishna judgment, they are binding in nature. Subsequent, they have to all steps taken, steps invalidated. They have moved before the Supreme Court, withdraw the SLP, who the state of Bihar as well as the B.Ed candidates. Now, whereas one from state of UP come up, they may be from state of Manipur, one can come from the state of MP, one can come from state of Chhattisgarh. They have not secured this court. Final view when the notification has been declared invalidated. The appointments were made subject to outcome of the Devesh Sharma's SLP. One of the applicants is Devesh Sharma himself before this honorable court. In whose SLP the judgment was upheld and notification was filed. Now, my they want to continue, let it not be the BSPC candidates, let it not be the B.Ed candidates. The notification was quite keeping in mind the right of those children who are now being allowed to be taught by these ineligible candidates without having a training. Article 21A is working day by day. Today, also a person who is ineligible to teach is taking up a class. Who is representing that child before this honorable court? We may not go into service, they may not continue in service, but the fact remains that the notification was quashed because it was taking away the right under Article 21A, that is right to quality education, a right to be taught by a person who is very well trained. Now, if a single day continuance of them is infringing their rights.
Where is that judgment of the Bihar High Court?
I provided a compilation. Please see my website.
They were dealing with a situation where B.Ed appointees were there.
Yes. And kindly see, my lord, what was taken up before the division.
What was the finally? What
They
was
said that the judgment of the Supreme Court of Devesh Sharma and Bhagwan Krishna, they are binding we have to go by that.
Hmm.
So meaning hereby that the B.Ed candidates were to make room for other CLA candidates.
What did they say about those authorities?
That-
Patna High Court.
Uh,
Patna High Court is subsequent to Devesh.
Yes. Patna High Court is subsequent to Bhagwan Krishna also. It's a free judgment, Malad, if I can read this.
Where is that?
I provided,
The compilation.
no, it's a separate set. It's provided today itself. Which is with the Dipankar Gaurav's order. The first part is Dipankar Gaurav's. Yes, now this is where the DNS candidates, DNS candidates include their SFP. The second order is the Bihar High Court order, 22nd of September. Now, Maharaj, can we see what the Bihar High Court has dealt with? The respondent status filed the above application. Where is it, Maharaj? It's a lot of work. The second order is said 22nd of September for the division bench.
Yes. Yes, yes. Oh, please read it.
He Devish Dipankar Gaurav. The top one is Dipankar Gaurav. What you covered, Mark? I can provide myself.
Have you given 2 copies?
Yes, I've given 2 copies. Now I'm giving this copy.
Issue copy to me.
It- Gaurav. Like I'm given analysis. Now Dipankar Gaurav is the order member. Let the B.Ed candidates withdraw their SFP. After arguing for a while, learned counsel for the petition submitted that the client would not like to proceed with this petition. The petition recording the expense was withdrawn along with pending applications. Now this was withdrawn against this order. That is the next page.
Hmm.
The respondent status filed.
Patna High Court order.
Yes, ma'am.
This is 22/9/23. Yes.
The response status filed the above application seeking to clearly allege uncertainty prevailing by reason of the 3 orders of the Honorable Supreme Court annexed to the interlocutory. Annexure R by 1 the judgment of the Honorable Supreme Court in which the judgment of the Rajasthan High Court, setting aside the notification dated 20/2018 issued by the NCTE to include B.Ed as an eligible qualification for primary school teachers was upheld. It was categorically held that B.Ed cannot be qualification for the purpose of selection of primary school teachers to teach students to be class 5. Annexure R2 was passed in a case where the very same notification was challenged, which was held to have been quashed by the judgment at Annexure R1. The consequential advertisement and subsequent steps taken in pursuance thereof stood invalidated. It was specifically noticed that the state of Bihar was not a party in the above reputation, but the free judgment specifically recorded that it is expected that the state of Bihar will take into account the judgment at Annexure R1. Annexure R2 is a special new petition where the interim order issued by the High Court of Chhattisgarh, which state the recruitment process came to be challenged. The division bench of the Honorable Supreme Court set aside the interim order and clarified that the recruitment process would be subject to the result of the consideration of the writ petition, which can only be in consonance with Annexure R1. We do not think that there is a lack of clarity insofar as the binding nature of the judgments of the Honorable Supreme Court at R1 and R2, and that there is no apparent conflict in the order at Annexure R3. We find the petition to be misconceived, the interlocutory application stands rejected. So, under Annexure R2 is that order which says that the advertisement on all steps taken thereto is put invalidated. Now, there, my lords, against this, the state of Bihar went into SLP, that is at the next page. It was listed before Justice A.S. Lopanna's bench, which passed the interlocutory order in Chhattisgarh High Court. Here, my lords, it was withdrawn. The next senior counsel for petitioner seeks leave to withdraw the petition. Permission was granted. The special leave petition was as withdrawn. Then, my lords, the B.Ed candidate went before the bench of Justice Anuruddha Bose, who delivered the judgment of Devesh Sharma. Here also, after arguing for a while on this 31st of August, October, they have reviewed the SLP. So, in all, my lords, it is very much clear that any appointment of the B.Ed candidates based upon the notification of 28 June 2018 in anywhere in the state of in this country, in any state, now that is invalidated. They cannot continue for a day more. What to say, all of they were following this mandate.
All right, so we proceed to the other.
Just kindly have a look on this.
Only one thing, Lord.
Yes.
But that doesn't
Please cite all your judgments which you are during your arguments. We
My
heard his arguments, we will hear your argument.
My Lord, what happened?
We'll pass it over. We'll pass it on.
At the outset, first my learned operation of his locus. Because he has not, in his long argument which he did just now, he has not disputed that all his petitioners, my lord, have failed to qualify in the test.
He needs
So-
a statement.
So, Lord, that is my categorical submission that 2,000 posts are still vacant. And,
You know,
Lord,
we can always meet that,
and what my
Argument.
learned is arguing on behalf of the children. This is not PIL. It is a petition vindicating the rights of those people who probably claim to be displaced because of the B.Ed candidates. No, you cannot argue for the children. This is not PIL. First, you tell where is your locus. If we are,
Yeah.
if our
Yes.
appointment.
all right, Mr. Rupa, if a diploma holder has been subjected to selection and found to be unfit and not appointed, then that's the end of the matter for that candidate. That's the end of the matter. So we'll observe that.
No, that has to be ascertained.
So that
That has to be
No, we'll leave it to
That is
the recruiting agency. Why should we undergo all that exercise?
We're not entering into an academic question, my lord. At the, it's my humble. At the instance of a person who has no locus, my lord may not be required to enter.
Which,
Why? Why? Because when you have failed to qualify in the written test, how you can challenge? See,
One time they say that we are another time they say we are failed. What, are you saying, are we appointed or are we failed?
No, they have one, they have.
have you pointed out?
Because I'm not appointed, it's not for the.
Mr. Counsel, Mr. Counsel,
My instructions are to.
please.
They have failed to qualify.
Yes, what is your name? What is your name? Why are you arguing with the other counsel? Whatever you want to say, you have to address to the court, not to the other side. If you want to argue with the other counsel, go and sit down in the bar room and do whatever you like. But not here.
That you first demonstrate that why those 2,000, why the return, there is no return.
No, let us visualize. Let us visualize what kind of categories of candidates will be there or appointees will be there. One, you say that diploma holders subjected to selection but found unfit. This is one. All right. Diploma holders subjected to selection, found fit and appointed. This is the second category. Third category is B.Ed candidates who don't have a diploma, found fit, appointed under the notification of NCT. The fourth is the B.Ed candidates who do also have a diploma and also appointed or not appointed, we don't know. So there can be various categories which can be visualized. Once the Supreme Court has settled the main legal point,
There are two.
What the starting point should be the locus of it.
There are two.
If I have found whether my learned friends.
please point out that which
There are two.
diploma holder was subjected to selection but found unfit and yet he is the petitioner.
I take the categorical submission in paragraph 17 of my return. It will not be out of place to mention here that 25,000 posts were notified by the government, out of which 22,000 have been. 3,000 are vacant. Means even if we are out, our learned friends' clients will not succeed in this getting.
They were to such.
Why they want to indulge in this academic exercise? Because
Appointed despite having qualifying marks, you make a statement that I am not seeking qualifying marks.
And the state-
Tell me so that.
that will be made by the state
When the
government.
state has-
No, the statement of.
But this is not an issue, Lord, which will be decided in piecemeal method. Me and Mr. Gillian, that's why we are not shying away from education. But we do not want not that today one order is passed, then again the state government comes with some facts, that will create complication.
No, it isn't. The ball is not in their court. The ball is now in the court here. We'll categorize, we can visualize all those categories right here on the basis of facts. And then we'll say you do this with this category, you this with this category, you do this, and thereafter go ahead and to fill up the vacancy.
There are two, there are two reasons.
This is where Malas they are hiding gloves. For 1 year you do not file. Last time it was argued we didn't raise this submission. It was only for the ad hoc bench. That it was not finally. Now, Malas, it was kept with this very much clear intention. 30th it would be decided because we were not available on the next 2 days. That I moved an application that I'm not available. Now, Malas, today they make a submission not on legal points. They make a submission that let there be my submission is very limited. But then you can still continue on. There may be 10,000 available cases. If you are intended, but do you have a right to continue in surveillance? It's not a public interest. No, I'm not sure public interest. I'm talking about a legal aspect number one. You have the legal aspect number two is that despite I have secured the minimum qualifying marks, I have not been given appointment because my
Who is for the recruiting agency? You are for the recruiting agency. That is what? Which is the recruiting agency? And you file a reply.
Qualification and acted by the department plus what is advertised on their direction and all the advertisement examination.
Alright, and the interveners are all which category of
We are one of
appointees?
We are one of the.
Your appointees?
We are the person.
We had appointed.
Yes, we are.
All interveners?
Yes. We also, we are the, we are.
All.
And if you watch it, because they went to the Supreme Court and Devesh Sharma moved that.
We'll ask for your what options are available to you. And then see on the basis of law whether to accept your option or not to accept your option. Give you a hearing.
There are two different. In one of the.
Question is whether it should be here today or not.
In my opinion,
Arguments are already over.
Because it's already kind of bartered.
we are.
I cannot technically say it's bartered because it's a different bench is different.
My submission is, it would be appropriate that the state government is given a short time to file it. So that they also spent out as to how many vacancies are advertised, how many persons have been appointed.
Why should we go into all
No,
that?
that will be required, man. That will be required.
Their domain.
One of that will be one of the
We will say we can visualize 3 or 4 categories.
One of that is absolutely.
And then we have to say who is going to be out and who's going to be
Why I say.
in those 4 categories and then leave it to the state to fill up.
The writ petitioners who are there. There are 2 written. In writ petition, there are 2 petitions. Both those petitioners have been appointed. So as far as one petition is concerned, there are no locus to say anything in the matter because they have already been appointed. The another matter is that my friend says they are not very sure as to how many persons are left.
They are diploma holder.
Well, yes, they are not.
None of them is appointed second.
Both the petitions, one of both the petitions, they are the diploma.
They have been appointed.
No, in one case they have been appointed, both the petitions. These are the appointment order and let them say that no, they have not.
You are talking about which case?
Well, this is responsible. It's 1376. This number 13767. In this one, there are 2 petitioners, Kesri Nandan Sahu, and both of them have been appointed. These are their appointment.
The first case.
This is the first.
There are 2 petitioners.
2 petitioners. These are their
Kesri Nandan Sahu
and the another Rohit Chaudhary.
who is representing them?
They are not. Yeah.
They have been appointed. They have been appointed.
Petitioners are appointed.
Then what is your grievance?
The second petition, none of them have been appointed.
No, we are talking about the first one.
The first petition was filed prior to the declaration of the results and the advertisement notification was issued.
Then it is infructuous.
Even if it is get infructuous, Malas, it will not be get infructuous for the notification in the real sought for. Because it is only in respect to one of the part that I should be appointed. But the notification, the rules is still under charge. That challenge goes with the second of the petition when none of them have been appointed despite securing the minimum qualifying mark. So, to the second petition also, Malas, I was still present. I will present the second petition
Now
also.
we come to the second petition.
Now, how is the second petitioner?
Because
His cause is still alive.
for the reason that the vacancies have been occupied by B.Ed candidates and we have not been given appointment despite securing the minimum qualifying marks.
You say both have been appointed.
There are 4 writ petitions. In one
They
petition,
talk about now, the first case,
first case both are appointed.
both are appointed.
Yes.
So then would you like to pursue that petition?
And he may pursue that.
Why? Why would you like to? What interim order?
Appointment are subject to outcome of the rate. So this petition would survive alone because all recruitments are subject to outcome. And even if these two persons are appointed, the recruitment exercise based upon their eligibility, that cannot be declared infructuous. The second was checked with this, there none of them have been appointed.
Did you mention in that WP that you were appointed?
That
They have not disclosed it.
the time when the rate petition was filed.
When were you appointed?
Well, these are 4/4/2023.
Yes,
Both these orders are 4/4/2023.
I can see when the rate petition
They never disclosed it. We have been saying,
was filed.
no, thereafter, we have been saying it on every day. Then you say, no, we have not been appointed.
First day itself, I said that two of the persons have been appointed.
They should have said
Rest
that.
are not appointed.
They should have said that.
When did you file this petition? 22/6. 22/6 it was filed.
Was filed once.
All right, filed. When was the result declared?
8/8/2022. That was for eligibility purpose, and then appointments were issued by us on 4th of April 2023. Prior thereto, the lordships made the recruitment exercise subject to the outcome of the investigation on the Devi Sharma judgment. Thereafter, they moved an IA before the Honorable Supreme Court. That IA was decided, no relief was granted. Then they moved IA before this Honorable Court, never revealed this fact that we were there before the Honorable Court. I pointed out this fact.
In daily shown them.
Then the second petition is already there, when the persons are not being appointed. They have secured minimum qualifying marks, are vacancies being occupied by these period candidates. We have not given.
Minimum qualifying marks does not give you entitlement to straightaway appointment.
Yes, ma'am.
It is based on merit rank.
They said
It
we
is
are
not.
ineligible.
It is not.
They said that we are ineligible. Look at that. Okay. And I can only be eligible if I fail to secure minimum qualifying marks.
Yes, there's another question which arises is, when this entire exercise will be considered again, all 3, 4, 5 categories, and then the entire exercise is considered, there may be candidates who are diploma holder who may have been secured more marks than them. These petitioners in Kesari. So then if that is so, then they'll have to be out.
Yes, we have candidates.
No,
Even we can be out. The officers are saying that even we can be out.
here candidates have occupied the posts which were exclusively meant for diploma. Now, once the B.Ed candidates are out, in case they are out, then the entire exercise of
When reshuffling is
the select list will have to be made again, based on the exam.
Yes.
Was it exam or what?
It was an eligibility examination.
For the new draft, it will have an impact, even there was reservation applied, there should be registering, everything.
So lot many things will have to be reworked.
But now for that purpose, the state will have to give out a reply. The state will have to come out with the figure. For I said 35,000 vacancies were there. Why only 22 were appointed? 3,000 candidates were not found eligible. These candidates were not able to be qualified in the examination. We do not know that. Now we are carrying out this whole exercise at the instance of these candidates, who out of which 2 have already been appointed, and remaining we do not know whether they will qualify in the eligibility examination. We do not know that.
Now, why would I come before the court? I told the simple, if I am ineligible, why would I come before the court? Let's argue this one.
And then my lord said that clearly qualifying in the examination could not secure the appointment, that their merit position has to be seen. So the state has to give a reply to that, my lord, as to what would be the position in respect of which candidate.
Scorecard is there. If you go out, I will come to the cutout. So you just answered it how you are there to pretend on service.
What's your local yes?
So that same issue was raised.
So I think lot many things will have to be reworked.
एक सेकंड में सर ये पिटीशन देख लेना
नहीं ठीक है,
सुप्रीम कोर्ट में लगा
तो आप बताइए पर
इसको सर स्टेट पर
कब करेंगे आप? कब करेंगे? No, not movies. You're waiting for 1 year without filing any reply. Sit down with your OIC and make your reply this week. We'll place it next week. Otherwise, everything will be washed out from the memory. Twentieth, week commencing 20th will,
What's my IME option of
which I
T65?
will hear you. You have a right to only audience, nothing else. You have no right to any relief.
We allow option of case law.
No, please don't complicate this. We'll hear you, that's all. That's all.
My.
Well, it's very clear that state unfortunately has not yet responded to the petition despite the same being pending more than 1 year. Next. The state council representing the court is directed to file a reply positively within 10 days. So that the controversy which has foundationally been settled by the apex court by the judgment of Devesh Sharma is resolved in these petitions, which are all filed by B.Ed appointees as well as diploma holders. So, besides 7, all the remaining 3 are filed by B.Ed appointees.
They all are fine to hear.
The first one is by the diploma holder.
Petition, petitioners are all here.
Interveners are not.
Petitioners are here.
Diploma. All appointed by diploma. All finished. Next, the list in the week commencing 20th November. Huh? You can appear virtually. Virtually you can appear. Why do you travel all the way?
Why this technology is very
Use it.
also.
Use it. What is the technology for if you don't use it?
Plus, one person appearing on physical side, another appearing on through PC.
We allow hybrid hearing. Why not?
Still, I think request.
No, we don't know because we give you a date. On that date, maybe we have already fixed about 1 or 2 already cases which will take time. So let the computer decide. Computer, searches for vacant slots and then decides in those 5 days, 5 working days. So it can be between 20th and 24th. Any date. No, not 20.
23rd?
Let the computer decide. You come to know from your colleague here. So Thakur will tell you what date. Fixed date.
Everything would be managed. Everything would be managed. So we are what we to have against those who actually brought by in person and that is why after 21A based upon that you
That's why it's a short date is given.
so that is why I was requesting that
There cannot be more. It cannot be a shorter date. We will give you short.
and the requesting topics. You also be kind enough since any finance to that extent that we can provide any fixed copy of lordship price any day.
We will come to know about the date.
So that is the nature that it
In advance, you will come to know the date. At least 1 week in advance.
that would be a tentative date, that will not ensure the skill of the case. That is what my son.
No, it won't be a tentative date. This would be issued prior to the Diwali vacation of that week, I think.
Yes.
It will be issued on 9th of November. It will be issued that 20th week commencing 20th list.
Then my insight of this would explain that whatever date we show whether the matter would be listed on that day, that is what my anxiety is. If it is listed now, that would be, but if it is tentative in the nature that it may then be postponed by the registry itself, that would be difficult for us.
That normally does that.
That is why I
When we give a fixed date or a fixed week, it is always listed in there. Always. Which, but it is made clear that the state council should ensure filing on reply, failing which coercive steps would be taken against the state functionary.
It may also be like, if it is, there would be final hearing in that. But otherwise, or again, they would seek some adjournment for any other
It
reason.
is, the parties are at consensus, then the matter would be heard finally in the next stage.
There are also two lateral demonstration programs where someone needs to be done. Unfortunately, a mirror has to happen. Yes, in right.
188
One,
1800. Oh, and तो लगे हैं आज विचार
On the delete side, conflict test will be taken
state functionary, state functionary. You want that to be also added? I have continuously.